book symposium on Kenneth Westphal's book, How Hume Can't Reconstruct Natural Law, Justifying Strict Objectivity Without Debating Moral Realism. Professor Westphal will first give an introductory note about his book, and then we will have a seminar and critical remarks on his book from 6 contributors. I will first introduce Kenneth Westphal. He is a professor of philosophy at Boğaziçi University in Istanbul, and he is a professional fellow at University of East Anglia, Norwich. And he is one of 4 editors of Northern European Journal of Philosophy. He earned his doctorate in philosophy from the University of Wisconsin-Madison, and his primary research interest is the character and scope of rational justification in non-formal substantive domains, in epistemology and history of philosophy of science, and in moral philosophy, including ethics, justice, philosophy of education, history and philosophy of law. His research integrates systematic analysis within contemporary and historical philosophy, and integrates analytic and hermeneutical approaches and methods. Westphal was Associate Professor of Philosophy at the University of New Hampshire in Durham, and held professorships of philosophy at the University of East Anglia, Norwich, University of Kent, Canterbury. He has held Humboldt Fellowship at the Universities of Heidelberg, Bielefeld, and Göttingen, and was a Leibniz Visiting Scholar in Bielefeld. He held visiting professorships at Purdue University, Evanston University, and Martin Luther Universität Halle. Some of his books include Hegel's Epistemological Realism, Hegel, Hume und die Identität wahrnehmender Dinge, Hegel's Epistemology, Kant's Transcendental Proof of Realism, and How Hume and Kant Reconstruct Natural Law. He edited Frederick Swill's papers and a bunch of other edited volumes, as I can see. And he has published more than 150 research articles. We welcome you, Professor Westphal. Thank you for coming by. Please.
Thank you, each and all, for coming and for your interest. I hope what we do today isn't a disappointment. And I'm grateful for your patience with my speaking yet another language, this one English. Please do interrupt me if I don't speak clearly enough or if I speak too quickly. And if this might be any help, if you wish, we could conduct some of this auf Deutsch, just as an alternative. I'm sorry, I have not yet had an opportunity to learn any Serbian. So thank you very much for coming. And let me try to say a few things briefly about what I tried to do in the book. It really is the result of, well, let me put it this way. I tried to do the kinds of studies and research required to write this book. The issues have been with me really from childhood. And I first was exposed to Hume's theory of justice in an undergraduate course in political philosophy at University of Illinois, Champaign-Urbana, that was taught by B.J. Diggs. And Diggs was one of the few people who paid any attention to Hume's theory of justice at that time. And that turned out to be an extremely fruitful beginning for me, in part because already I was concerned about whether it could be possible to, as it were, recover at least the core content of a defensible, tenable, contentful natural law theory without having to get involved in issues about moral realism. That is, the notion that there are somehow human mind independent moral facts of the matter that we need to properly account for, because debates about those kinds of facts have for millennia been enormously controversial, especially among philosophers, but not only among philosophers. And at times not just controversial, but the controversies, as you are painfully aware, too easily break out into open armed conflict and worse. So I've been trying to figure out then whether or how it might be possible to identify some very basic moral norms without having to invoke issues about moral realism or anti-realism, and also without getting, I think, sidetracked by issues about moral motivation and its purported relations to moral justification. And I have found myself quite at odds with most everything that's happened in ethical philosophy in the Anglophone 20th century. It turns out that right up to the end of the 19th century and the very beginning of the 20th, everybody regarded moral philosophy as the genus with two proper species, right? Ethics and justice. And also, those who were interested in moral philosophy were equally interested in issues about philosophy of law and philosophy of education. And this is also true of none other than Henry Sidgwick, who mostly now among Anglophones is remembered only for his methods of ethics, to the utter neglect of his own principles of political economy, of the fact that he was the head of the statistical section of the Royal Society when that section was responsible for economics prior to establishing economics as its own discipline, that Sidgwick had written a really quite wonderful book on the history of European polity. And he understood political economy and wrote on it as a moral science, not only in the sense that it has to do with human phenomena, but that political economy is a normative science. And all of that gets set aside in short order at the beginning of the 20th century among Anglophones with the sudden advent of moral intuitionism among Moore and Ross, and also C.D. Broad's 5 Types of Ethical Theory. Now, much better attention to Sidgwick's work was given by Jerry Schneewind in his really quite astonishing study of Sidgwick's thought and philosophy from '97. But Anglophone philosophy remains mostly very compartmentalized because it makes life simpler. So I have been trying to reestablish what I still regard as the proper genre of moral philosophy as containing the two equal species, ethics and justice, and trying to point out that issues about justice are not just corollaries to ethics, which is how they've been largely regarded, which is why in the Anglophone tradition, Rawls's theory of justice was taken to be such a breakthrough. He finally said, I'm just going to do political philosophy. I'm not going to try to deduce it out of ethics or as corollaries to ethics. I'm not persuaded that Rawls's methods were sufficiently fundamental. We can discuss that later if you wish as to why. So the effort has been to devise a certain kind of, that is a specific kind of moral constructivism which can, I think, identify and justify fundamental moral norms, juridical norms, norms of justice, by appealing not to the kinds of subjective factors of states of awareness that have been prominent in, well, Hume's own ethical theory, and also in most varieties of contemporary moral constructivism, because they all face exactly the kind of problem that can be found within Hume and that certainly was central to Kant, namely, if we base the identification and justification of moral principles on subjective states of awareness, we wind up with an account of those principles that can't address anyone who simply lacks those states of awareness, or even less honorably, who denies having them. So I think all of these varieties of the contemporary varieties of moral constructivism that do take alleged states of awareness as basic have given in to moral relativism and pretty nearly conventionalism before they get started because of the choice of departure, right? The basic elements in those constructions. And so what I've looked to is Hume having identified a different way of constructively identifying and justifying fundamental principles, taking into account quite basic and pervasive facts about our very finite form of human agency and our manifold dependencies and manifold kinds of finitude whereby we are subject to extortion, injury, deception, and other such unwelcome actions. And so, without any regard to motives or sentiments, in his theory of justice in the treatise, Hume argues strictly on grounds of utility that for human life to be possible at all, we require very basic principles providing for the acquisition and justifiable use and also transfer of goods, including principles then governing fidelity to promise and contract. And in conditions of even moderate population growth, some version of more or less formal institutions of government to identify and adjudicate disputes about rightful use or unrightful misuse of goods or sufficient fidelity or infidelities regarding promise or contract, and to determine what's proper redress for violations or failures of performance. So we get quite straightforwardly on Hume's account at least the rudiments of civil and perhaps even criminal justice. And then he says, we also then have these coordination problems, namely, we all benefit enormously from various kinds of public works, and it's an entirely suitable function of government to organize and commission such works, any, highways, harbors, and so on. So we get in those ways, on grounds of utility alone, they may be elementary principles, but that doesn't make them in the least trivial. What we don't get with Hume and his account of justice is much attention to issues about legitimacy. And given that Hume's own project in the treatise is an explanatory project, that's not a surprise. There are some traces of his concerns with issues about legitimacy and with legitimate distributions of power as well as wealth in some of his later essays. He certainly is aware of how often and how easily powerful men have dominated women, slaves, and other groups over whom they can wield power. So he's not insensitive to those issues, but he doesn't have a philosophical response to them. Annette Beyer has drawn attention to the great expansion of Hume's concept of justice in his History of England. And I think that she's right about that. But she says nothing about whether Hume justified his expanded concept of justice. And I don't think that he did. And certainly she doesn't show anything that indicates that he did. But those are the issues that are directly posed by Rousseau, famously, and I think quite rightly, and central to Rousseau's requirement for legitimate law, legislation, government is what can be called, and Fred Neuhauser calls it this, right? The independence requirement. That within a legitimate government and legislation, hence within a legitimate civil society, no one is to be allowed to acquire or to wield any kind or extent of influence, prestige, or wealth, or any other form of social power with which he or she can unilaterally dictate what anyone else does. So that cooperation is always on the basis of voluntary agreement for good reason. And it's not a surprise then that this is exactly what turns up in Kant. Also under the heading of the independence requirement, right? It is Kant's sole innate right to freedom, spells out Rousseau's independence requirement, and does so in connection with Ulpian. I mean, he's modified Ulpian's phrases. But running through this entire approach to legitimacy is the old Roman law adage, right? Injure no one. And then, of course, there are issues, what counts as injury, juridically? And I think that Kant's principles can help quite a lot with that. And so I think the fundamental point of Kant's universalization tests is that justification in all non-formal domains, but including ethics and justice, rational justification of claims or principles or judgments, or also those maxims that guide action, requires that sufficient justifying reasons for the claim or action or maxim are such that they can be addressed to all others, such that any and all others can identify and assess those grounds and likewise find them sufficiently justificatory. All right, that's the universalizability built into Kant's universalization tests. And Kant is already working with exactly that kind of communicability requirement in the doctrine of method in the first critique. It's not new to the groundwork. It's not new to the metaphysics of morals. It's fundamental to the entire critical philosophy. And this is also, if you don't mind my looking ahead just a bit, this is exactly what Hegel learns from Kant. And those are really the core conclusions to Hegel's analysis of mutual recognition in the phenomenology of spirit. But I'll leave Hegel aside on this one, except to mention this point, and that is, Hegel too sees what Kant had identified about this communicability requirement for justification that is a direct counterpart to Hobbes's problems in the state of nature, where, again, too much of the Anglophone tradition has been obsessed with Hobbes' alleged egoism. I think, in fact, he's not an egoist about human motivation. But the more fundamental issues that Hobbes raises concern coordination, intersubjective coordination in our use of goods, right? Simple, innocent ignorance of what belongs to whom and what she or he rightfully can do with his or her belongings. Simple ignorance of those relations suffice to generate the kind of total mutual interference that characterizes Hobbes' state of nature. And that's the fundamental point in Hobbes' reconstruction of what turns out to be an Epicurean natural law theory. I don't make that case. That's been done, I think, extremely well by Bernd Ludwig in his Habilitation from 98, excuse me, 98. It's a terrific book. If you're interested in Hobbes, read Ludwig's book. It's still ahead of even the most recent stuff coming out. And I mean, the Anglophone discussion of Hobbes is getting better on these points, but it's still working to catch up with what Bernd Ludwig did. Now, what Kant points out in the issues about justification is that there too we confront issues of coordination concerning our judgments about what is or is not sufficient justificatory grounds for which claims, judgments, maxims, or actions. And that either we identify grounds, and hence also by them actions, which can be omnilaterally justified for sufficient reasons, or we're stuck within the domain of rational justification with a direct counterpart to Hobbes' state of nature. And Kant names Hobbes in this connection in the Doctrine of Method of the First Critique. And Hegel noticed that, right? If you think about the phenomenology of spirit, that marvelous section, right, der geistige Tierreich, right? That is the literary counterpart to a Hobbesian state of nature, not by accident. Hegel was, it turns out, an extraordinarily subtle reader of Kant's critical methodology. So the Hobbes point about coordinating intersubjectively publicly identifiable principles and practices and then specific titles of who is entitled to do what with which things and when and how, that those fundamentals of justice must be public principles, procedures, and titles in order to relieve us of our natural ignorance of who is entitled to do what with what. And so justice must be public. Right? When Hobbes says that justice pertains to men in society, not in isolation, he's not espousing conventionalism. It's rather this point that the fundamental moral problems start with problems of coordination. And those problems are exactly the problems that Hume takes up in his theory of justice in the way that I mentioned about basic rights, about acquisition, possession, use, transfer, promise, contract, and the rudiments then of civil and criminal justice. And the interesting point about Hume's theory of justice in these regards is that in identifying and justifying these fundamental principles, even in terms solely of utility, at no point does Hume appeal to anybody's sentiments or motives. And when he makes his famous example, am I going on too long or is this okay? I'll wrap this up in just a couple of moments. Hume rejects act utilitarianism and adopts rule utilitarianism with a quite direct and I think also decisive example. His own example is restoring a fortune, right, a vast sum of money to a seditious bigot. That's his own phrasing. Or a miser. He says, if you do this, plainly the public is not the benefactor, right? Because that money is either going to be taken out of public use altogether, or it will be used for seditious or bigoted purposes, right? So plainly the public is not going to benefit by that. But the rules of justice require the restoration of a fortune to its rightful owner. And that's a much more fundamental point of public justice and utility than the further consequences. But when he makes that case, nothing about anybody's character or motives or sentiments, not of the agent, not of the miser or the bigot, and not of any ideal specter, play any role at all. Zero. They just disappear. Because they're not necessary. Hume himself shows us how to identify and justify a fundamental moral principle without any appeal to his own sentiment-based ethical theory. Brilliant. And, you know, this was really quite common procedure in modern natural law theory, which got lost because too much of it was done within a more or less theological worldview, and the authors tend to get too carried away with that aspect of the view rather than looking at these fundamentals. But I mean, Hume is not doing anything radically different. I think he's paying much more careful attention to these basic principles than most of his predecessors had. And that's not nothing. But it's exactly that same kind of analysis that Kant gives us about fundamental rights to possession, acquisition, possession, use, at the beginning of his Doctrine of Justice. All right, essentially sections 1 to 9 of the Rechtslehre, but amplified by Kant's use of Rousseau's independence requirement and a much more sophisticated account of rational justification, including this condition on communicability of sufficient justifying reasons that I mentioned before. I think I should let that stop, but thank you very much.
Thank you. Before we begin, let's start with, I think, the youngest participant, with Miloš Marković. Miloš Marković is now a student at University of Graz by Matthias Klett. I told you because you know that book that
Yes.
Klett made about Alexei, and he wrote his PhD thesis on Alexei's Rechtsphilosophie.
Thank you very much, Rastko, Professor Westphal, for the invitation. Yes, you already mentioned that I'm a PhD student of law. I wrote a master thesis about justice in contemporary legal positivism, and in the current time I'm writing a doctoral thesis about the principal theory of Professor Robert Alexei. So, as for the problem of how human can reconstruct natural law, I found some interesting points that I would like to emphasize just to call our attention to them, and I have some points that I didn't quite understand as a student of law, and that I would like to clarify today, if possible. So, things that I find interesting, the definition of moral realism. It's very important to make a difference between a thesis that there is a definite answer, whether one is morally obligated, and the thesis that there are some human mind independent truths. Because obviously moral constructivism can give a definite, can endorse the first thesis, but moral realism is limited to the second thesis. Second interesting point are those 5 social coordination problems of Hume, and they are actually reminiscent of Hart's, Herbert Hart's legal anthropology in his The Concept of Law. He speaks about 5 truisms, which are contingent facts, but nonetheless universal, about human nature. Human beings are vulnerable, equal, relatively equal, their limited resources, their sympathy is limited. Hart says they are neither angels nor devils. And there is limited contemplation and determination, or limited understanding and the strength of will. And all of those truisms, they justify certain rules. Hart makes difference between primary and secondary rules. So vulnerability of human beings justifies the rules that demand the protection of persons. The equality enables coercion, because if there were some greater inequalities among human beings, some are greater and stronger and smarter than the others, then there wouldn't be possibility of those less strong to impose any coercion, any sanctions, any obligations on the stronger ones. Limited sympathy makes the coercion necessary. Limited resources, that is interesting. For Hart, limited resources are enough to justify both static rules and dynamic rules, in the sense that static rules regulate property. Hart doesn't use the term possession. And the dynamic rules that regulate promise and contract. In contrast to Hume, who needs some further premises, further social coordination problems in order to make a complete circle, the complete system of those static and dynamic rules regulating possession or property and promise and contract. And limited contemplation and determination, they justify the secondary rules, which give power, legitimate power to government to organize the society, to ensue authoritative rules. And that is actually the 5th social coordination problem that Hume also discusses and uses as a justificatory point for government for rules protected with sanction, it as legal rules. The third point that is also that I found very interesting is your remark that the issues we confront today, I mean, primarily legal philosophers and moral philosophers, are far too complex to afford a dismissive attitude toward our philosophical predecessors. But in regard to that, I had an impression that maybe too much is written about what other authors have already written. So we are just discussing what somebody said, and we are like having a meta debate, forgetting about the core issues and just discussing about sentences or even words which are in some works of famous authors, but in that case we may really disregard the core issues, and if that happens, then this meta debate about the positions of authors is also in vain. The points that I find problematic, that I couldn't understand thoroughly, are the following. Your contention that moral philosophy entails ethics and justice, because I see justice as a moral value or a moral virtue, not a philosophical discipline in practical matters. And it is hard for me to conceive them on the same level as to coordinate species, because ethics is like a synonym to moral philosophy, and justice should be the object of legal philosophy, maybe also political philosophy. So the possible proposals would be good and justice instead of ethics and justice, or ethics and legal philosophy as coordinate species of moral philosophy as a general term or notion. That is on the page 2. On the page 25, we are talking about basic moral principles in ethics and jurisprudence. So there is also some somewhat different terminology, which calls our attention to the possibility to reformulate those elements of moral philosophy or species of moral philosophy. Also on the page 181, as for analytical or Anglophone analytical ethics, in contrast to moral philosophy, the ethics is primary, while social and political philosophy, id est justice, is secondary. So we have, like, on 3 different places in the book, 3 different terms for problem of justice, which is as more times stated, social problem, social issue, or has social character. So we can speak also of legal philosophy or of social and political philosophy. Yes, and that is how I reached the conclusion, and please correct me if I'm wrong, that the moral philosophy is divided in the individual part and collective part. It is not that good stated, but individual problems, which is the object of ethics, as moral philosophy in the narrow sense, and legal and political philosophy deal with the collective issues. Yes, and with regard to the same topic, I would also pose a question, because as a student of law, once more, I'll have to make my excuse. Is to comply with the dictates of justice an ethical or a moral duty? Further issue, optionality premise. Optionality premise says that the fact that the principles of justice are artificial does not necessarily mean that they are either relative, conventional, or arbitrary. But does it mean that the relative and conventional moral standards or principles are not arbitrary? And to what extent? Because I regard relative moral principle as based on an individual decision or individual will, conventional as based on collective will, agreement. But what is the difference to arbitrary? Are they both not arbitrary already, relative and collective? I am not able to grasp that. Yeah. I mean, it also occurs to me the difference of different types of moral relativism, descriptive, normative, metaethical. So it would, I would appreciate to clarify the matter. Okay. Yes, and the most important, or as important as the first issue, the difference between identification, explanation, and justification of moral principles. On pages 40 and 41, primarily. So we have identification of moral principle, explanation of our knowledge of them, and justification of moral principles, and further our knowledge of them. So Hume's task, Hume's project was purportedly explanatory. So he should concentrate only on explanation, or supposedly he concentrates only on the explanation in his moral theory, not in his theory of justice, explanation of moral principles. But I was not able to catch that fine difference between those two, especially because each definition entails a normative element, because it's not to identify principles, but to correctly identify, to properly explain, to tenably justify principles. So, I mean, as I read the book, to identify principles, I regarded it as a completely cognitive task, that principles are somehow given in advance, and we have to identify them, to state them, describe them, not prescribe them, and then to justify them as they are. But then the whole project of moral constructivism, and now correctly, so the proper identification, it seems to me as if it is it overlaps with justification of those principles, because how otherwise are we supposed to correctly identify them? That is also something I have a problem with. I couldn't understand it completely. Yes, and a little remark on the page 55. You contend that some acts of injustice arouse sense of injustice because they are unjust. But do some arouse, some acts, or all acts arouse the sense of injustice because they are unjust, as to Hume's opinion? Do I have time to go thoroughly on that one, Rastko? The time, do I have time? almost finished. Okay, so yeah, the question is once more whether some acts arouse the sense of injustice because they are unjust, or all acts arouse sense of injustice because they are unjust. And yeah, this is also a tricky one, I think. Is there a difference between being just and being non-arbitrary? On the page 58. That is still Hume. Yeah, impartial spectator to rescue. So, as complex social relations, the principles justice are artificial. Okay. But nonetheless, they are indispensable to human life, both individual and collectively. They are laws of nature. I.e., they are non-arbitrary. But further, so it's said, moreover, furthermore, they are also just. Why? For reason Hume provides in his integrated solution to 5 social coordination problems. So we refer to page 36, where that is the end of this discussion about social coordination problems. And they are laws of nature because they are solution to the principles of justice, to those 5 social coordination problems. But here they are just because they are solution to the 5 social coordination problems. So is actually justice, non-arbitrariness, or why are they just, aside the fact that they are non-arbitrary? Thank you very much.
Thank you very much. And no, I think these are very interesting questions, and obviously I regret having left some of them apparently open, but let me see whether I can help clarify some of them. Let me start with part of your remark regarding moral anthropology, or practical anthropology, as Kant would call it, and Hume's observation about our limited generosity and benevolence, and point out that it's that feature of what he takes to be human psychology, our limited generosity and benevolence, that at most explains why we need to pay particular attention to duties of virtue or duties of justice regarding others, and when we ought to be and how we ought to be more benevolent or more generous, right? So the fact of limited generosity only explains why we've got particular issues about when assisting others is morally a duty or requirement. It doesn't, right? The issues about limited generosity don't do anything to identify which acts are appropriately acts of assistance, right? So this is part of where Hume is engaged in a psychological, anthropological form of inquiry about, in effect, moral beliefs. But it can't address issues about which actions are in fact just or virtuous, or for that matter, supererogatory, right, above and beyond the call of duty. And in the Hume chapter, where you're, I think quite rightly, wondering what counts as explanation, what counts as justification, there's very little normative justification of these basic rules of justice because Hume's account is so much an explanatory account, namely seeking to explain why certain actions are called just or unjust. And at times, he wants the mere designation of acts as either just or unjust, or designation of acts as virtuous or unvirtuous, right, vicious, to constitute those acts as just or unjust, virtuous or vicious. All right, that's the strongest nominalist part of Hume's anti-rationalist explanation of moral language and moral beliefs. And that project in Hume has nothing to do with justifying those beliefs. It's only a matter of trying to explain how we ever come to associate, as he says, any moral sentiment of approval or disapproval of various acts which we happen to designate just or unjust, virtuous or vicious. So you're right, in that chapter there's very, very little about normative justification, but the issue about non-arbitrariness comes up this way, in that these basic rules of justice that Hume does identify, and he identifies in many regards why these are absolutely necessary for human life, is an important contribution to their identification and their justification, except that Hume doesn't make it out to be a normative justification. He does say, you know, it does promote general utility. He doesn't put it in quite those terms, but that's how he's thinking about it. But he's not offering it there as a normative justification of those principles. All of that awaits my getting to Kant. So the issues about non-arbitrariness are emphasized in the way I have to try to get philosophers to stop automatically equating conventional norms with arbitrary or optional norms, right, which has been rampant in the Anglophone discussion for the past 80 years. And I think it really is an insight on Hume's part that there are some norms which may well be conventions, may well be our artifacts, but are nevertheless entirely non-optional, right? Either we identify these and abide by them, or we solve all our problems by going extinct in short order. So there's at least a strong prudential reason to behave ourselves a bit better than we often do. But it's not a normative justification of so acting because it is the right way to behave in our dealings with one another. So yes, and I tried at several points, perhaps not clearly enough to indicate, of course, there are many principles that we have to establish conventionally. It's called legislation and custom. But these will all be to specify and augment the very basic principles of justice that Hume has identified in his rules of justice, and some further ones that I think Kant can identify, so that we can have, particularly as our societies become larger, more clearly stated laws governing property and its transfer, rightful use of it, what counts as harmful or negligent misuse of our belongings, right? Many of these things need to become specified as our societies increase in size and also as our economies become more complicated and as we start putting in so much more technology into the economies and into common usage. But what I wanted to try to emphasize is that there's a core batch of principles that we will have to abide by in one form or another within any feasible and within any tolerably just human community. Now, the tolerably just part, I think I only get to when I get to the Kant part of the book. But I think that Hume's insights about the rules of justice are a really good start, and in particular that he sees that artifice, right, literally making something, and hence that these most basic principles may be conventions. Nevertheless, there are simply no alternatives for us, given our finitude and our mutual interdependence. About the terminology and the genus moral philosophy. Yes, the terms could be swapped around, but I'm happy to go back to, Plato's laws and also Aristotle, right? The ethics and the politics, which are, two parts of one project, and how consistently that was regarded as moral philosophy. Also in England in the 19th century, right? Bentham and Mill, right? Bentham means that title, Introduction to the Principles of Morals and Legislation. And likewise, Mill in Utilitarianism, right? The last chapter is on justice. And he's quite clear, these rules are rules for the philosophers too, until they show us that there's something better we can do in these regards. And Sidgwick is quite plain about moral philosophy embracing both ethics and justice. So yes, we could swap the English terms, morals and ethics, but I think the tradition of usage coming from literally the ancient Greeks on down leaves us with a more established usage according to which moral philosophy designates the genus, and within it we have ethics, justice, political philosophy, philosophy of law, philosophy of education, and of course everybody from Plato, from Socrates, for goodness sakes, down to Sidgwick, recognized that these aren't separable compartments of human life, right? Ethics just isn't individualist in the way that moral points of view theory tried to make it so in the 50s. And that the individual questions about how each of us, I ought to behave, are shot through with all kinds of social dimensions regarding our associates, our family, our friends, the family from whence we come, and of course, all of our professional or vocational or academic involvements, and how we make use of public and private space and materials and resources. So I want to agree with you that there isn't any clean, plausible distinction between individualist ethics and anything more social. But that's how too many Anglophones have thought about ethics. And frankly, it starts in earnest with Moore, Ross, and C.D. Broad, right? It's Broad who first restricts attention to the ethical aspects of the writings of the figures he considers in his 5 types of ethical theory. He praises Sidgwick to the heavens for all sorts of things, but never mentions that Sidgwick wrote on political economy, the history of European polity, and many of his ethics on quite pressing social issues and political issues, or just complete disregard by Broad. And that's what goes forward in the Anglophone tradition, particularly so in the States, but very much so also in England. And it's that I'm really taking issue with. And yes, I expect this to make a lot less sense in Europe, and for that matter, anywhere else in the world. Because in Europe, there's been quite broadly, with one exception I'll mention in a moment, quite broadly, a much more, I think, generous and responsible retention of the importance of issues about politics and justice and philosophy of law. The exception is France, where essentially the influence of the CP, right, or should I say here, Capet, in France just squelched issues about philosophy of law and political philosophy, and much of the issues about justice until really quite recently, right? I mean, I've got French colleagues who are now doing all they can to try to regenerate political philosophy and theory of justice within Francophone philosophy. I hope that's some help. But thanks for the questions and comments.
Thank you, Rasko. Thank you, Professor Westphal, for this interesting topic. I have some two questions or let's say comments. First, two questions are concerned with some of my suspicions or let's say comments about making a Kant argument, but trying to leave out the question of transcendental idealism and foundations of a priori. So I suppose I'm certainly not an expert on the question of Kant's theory of possession, but as I read at least, this, especially first 6 paragraphs of the argument, Kant's core of the argument is to abstract from intuition explicitly, from phenomenal world, and let's say from the nature as a field of the concept of understanding. So what we have then that the object of intelligible possession is actually the clearly object of the will. So let's say it is a purpose as the object of will, as a positive causality. This is important because I think that Kant explicitly move out from the sensuous field and go to the field of nominal things or to the realm of ends. And the whole argument, at least before the paragraph 7, functions in the totally different world, let's say, in the world of noumena. Which helps Kant to make some arguments. He explicitly said we don't need now to concern with some physical problems because we are strictly speaking about objects of will. So what I'm skeptical about, the Kant probably is not just missed to mention some arguments that are anthropological, but he saw an idea to make an a priori foundation of this argument in the world of noumenon. I have no place for comments, at least in this first step, that are from the physical world. Important implication from this is that what actually Kant do that the totally different direction and consciousness of looking to a world as a world of the objects of will or purposes is now in the next steps applicated to the world of nature, which make some very important stepping in Kant's whole critical project, that application of the concept of freedom to the world of nature. So I'm little bit suspicious it is something important to held when we speak about Kant. The second problem is the question of the deduction of the fundamental law itself. As you surely know, we know that Kant, in Foundation of Metaphysics of Morals, made some argument that justifies the fundamental law relating it to the absolute value of the freedom. But in critical practical reason, he made a totally different step, and instead of deduction, he gives us first the fact of reason, which cannot have theoretical deduction, and then from this fact, deduct the freedom. So there are many interpretations of this problem. Karl Ameriks tried to downplay this problem and said that Kant simply see that he does not have this deduction. Honor O'Neill, who you admire here, tried to make argument that Kant here trying to say that and to make argument why all people have some consciousness awareness of the categorical impetum, which could surely contribute to some addition that how people are aware of these laws. But then I rather wanted to go to some other tradition, starting with Marcus Filošek, but then later. What I see is the spectrum of reasoning has some crucial role in connecting the faculty of the will, or something that is strictly in a division in Kant's philosophy. There are the faculties of knowledge and faculty of desire. So the fact of reason, if you understand it as a fact, as an act of free actor, as Kant understands it in some other words, as factum practica, made a connection and say why the fundamental law is practical in itself, why it has causality. So this important modeling of consciousness, I would say, play important role later in the critique, in the topic, and in the paragraph about the object of the practical reason. At least I read it that way, because that consciousness is a model of consciousness, how we could be consciousness of the object of the will. So both of these questions are backed up because metaphysics of moral starts with a question of division of the faculties, and fact of reason is again in paragraph 6 of Doctrine of Right mentioned as the only source for the consciousness of freedom. So what I think is, if we leave out these specifically transcendental idealistic problems of confrontation, first of ethics and then of rights, I don't think, I'm a little bit suspicious of what is left. And my second problem, or really comment, is to speak a little more about foundation of intersubjectivity. Of intersubjectivity, yes. And with reference to the foundation of state. Because generally, as you said something about it, I see that there is basically two perspectives. One is liberal, often prescribed to Hobbes, but I'm sure more appropriately to Locke, that there are private interests, private questions, individuals, and for some reason we constitute the public sphere. But there are many, as you said, that there are intersubjectivity that is in the play already from the beginning, but there are also some Kantian remarks that even the constitution of the state have some a priori intersubjective foundations. I will quote some of the moments. For example, that Kant after he speaks something about taxation, he said, the general will of the people has united itself into society, which is to maintain itself perpetually. And for this end, it has submitted itself to the internal authority of the state in order to maintain those members of the society who are unable to maintain itself, and so on. But what is important is that what Kant explicitly said, this is not individuals who united themselves into society, but the general will of the people, the Allgemeine Volkswille, has united themselves. On the other places, he speaks about originally and a priori united will. He said will that is omnilateral, that is united not contingently but a priori, and therefore necessarily and because of this is the only will that is law-giving. So these paragraphs explicitly says that Kant has some a priori theory of generally of united general will which probably could go ontologically prior to the theory of possession. I'm just putting it in a question. I just would add, those are quotations from Kant, but I'm now reading a text from Andrea Pinzani and Nuria Sanchez Madrid. They also add the argument similar to your, if the will is united originally and a priori, and if it proposes no right for a legal act for its union, then the idea of social contract among individuals became devoid of meaning, in the sense that they are also clear about avoiding contractarian solution. But there is also some problem, and I also have a text here from Roberto Pirni, because there are reasons, enough reasons, to presuppose that this intersubjectivity is founded already in the groundwork of metaphysical morals, surely have an implication, and actually most explicitly in the formulation. Yeah, but that is explicit in the question of justice, and doctrine of justice was explicitly founded in a formulation of categorical imperative that speak about realm of ends. So I'll finish it. Thank you.
Thank you. These are very understandable questions, and I have even more wildly heterodox views on them, which I will try to characterize. I can do no more than characterize them briefly, but this is part of why it's taken me so long to finally be able to come to write this book, is that I've been sorting out those issues in Kant's theoretical philosophy and his theory of judgment. And the issues about a priori principles or foundations in Kant's moral philosophy are crucial, but I really do take Kant seriously in his aim to develop a critical philosophy that is really quite radically different than not only empiricism, but also rationalism and prior pre-critical metaphysics. And that Kant's use of the terms noumenal need always to be carefully interpreted in context. He's often willing to help himself to those terms, but whether he's talking about anything metaphysical needs to be carefully checked. On Kant's view, anything which cannot be fully specified and justified on the grounds of empirical evidence alone will have some a priori aspect to it or other, and will for that reason alone already count as noumenal. And that may have nothing to do with the metaphysics of transcendental idealism and his critical distinction between things themselves and appearances for us. So when Kant is talking about intelligible possession, this is his way of restating, frankly, Hume's and Hobbes's point that relations of possession, in contrast to mere holding, are normative, right? Here, right now I'm holding this glass. I don't possess it, right? It belongs to the Institute. And Kant is underscoring this issue about relations of possession being intelligible in that they are not physical relations, but they are moral relations. They are relations we establish in part by establishing publicly identifiable procedures for acquiring and coming to own, rightfully possess, and use things. And all of those procedures and the specific titles that they can be used to literally generate are entirely normatively structured. And for that reason alone, they will count as numinal and intelligible in Kant's view, right? And so that's what he's working out in the opening sections on rightful possession in the Doctrine of Justice. About the use of the concept of freedom and its application to us, yes, Kant says numbers of things. I think that they are not inconsistent in ways that are often alleged. Yes, in the second critique, the critique of practical reason, he's explicit that the concepts of freedom and the moral law are reciprocal concepts, right? Only free agents are subject to the moral law. The moral law only pertains to agents who are free. And then the question is, which one of these can we use as a ground for knowledge of the other? But it's a ratio cognoscendi that he's after at that point. And when he there talks about the fact of reason, he is in fact invoking points about rational judgment that he had made already in the first critique about the constitutive contrast between simply finding oneself with beliefs or thoughts or whatever and making judgments, where making judgments involves assessing what beliefs or thoughts one has and their relevance to whatever their purported domain is, and the sufficiency of one's grounds for surmising or affirming or even demonstrating that the claim or the thought is correct. And those are topics that I went through concisely, but I think in pretty fair detail in the 6th chapter, particularly section 27. And this is surely one of the most heterodox things I have to say about Kant, but I have argued this several times in other places because this is not the book for it. Kant simply did not need transcendental idealism at all, and especially not to defend the possibility of free rational action. And sufficient grounds for ascribing freedom to us, both in thought and in action, comes from his account of the autonomy of rational judgment. And that's already there in the first critique. So I won't repeat what I've said there, but about his own contention that he needs the transcendental idealism and my contention that he didn't, one of the most basic points that I can summarize is just this. Kant, like so many others, took universal causal determinism within the spatiotemporal realm for granted. And he thought that it was demonstrated by Newtonian physics, particularly as improved and made more precise by Laplace. Now, Laplace did espouse universal causal determinism, but Laplace knew the difference between believing it and justifying it, and that has been lost on his readers. What Laplace actually says, and you know, the famous example of this it is an omniscient intellect that knows the current state of the entire universe every relevant law and the location and velocity of every, even the smallest particles, Laplace says such an intellect could calculate the entire state of the preceding universe and calculate everything to come so that the entire history of the universe would be present to it. And yet, this alleged intellect is doubly subjunctive in Laplace's formulation. Right? What he says is we ought to regard, and the French is envisager, right? Envision the present state of the universe as produced by the immediately preceding state and as causing the immediately succeeding state of the universe. But why should he say that in the preface to a book on probability? Right? It's a methodological presumption of empirical inquiry, whether statistical or causal. And Kant, I'm sorry, should have recognized that Laplace had stated a regulative principle of empirical inquiry. That's how Laplace states it, and he's right. But deterministic explanation requires an exact and sufficient causal explanation of the events or of the kind of events in question. And we have no justified claim to determinism about those events until we've got the complete and sufficient causal explanation. And that's a rare thing, right? Causal determinism. Yes, well, but there's something much more fundamental, right? Causal determinism requires a causally closed system. Nothing in Newtonian physics entails or requires a causally closed system. And as far as human behavior goes, we, as human beings, are not causally closed systems, not remotely so. If we did, we wouldn't want our coffee break. Or if we were, we wouldn't, this whole business about causal determinism is just a complete red herring, I'm sorry. And Kant has, well, this is one of the things. Do I have a couple more minutes on this? Yeah. Okay. In the Metaphysical Foundations of Natural Science, Kant realizes that he needs to justify not the universal causal principle that every event has a prior and sufficient cause or set of causes, but the much more specific principle he there identifies as a metaphysical principle that every physical event has a sufficient, perhaps, set of external physical causes. And he reiterates that distinction also in the third critique. He doesn't formulate that distinction anywhere in the first critique. But in fact, his analysis and defense of causal judgments justifies the more specific principle, and yet only in those cases where we succeed in identifying causal interactions among spatiotemporal events. So he does have a justification within the first critique of that more specific principle, but not a justification of its universal status regarding every event within space and time. We can justify claims to causal relations, causal explanations, only to the extent that we actually identify the relevant causal relations. And the extent of our identification may vary enormously, right? For common sense getting through the world, really quite abstract, meaning very general, unspecific claims suffice. Right? You know, I do not need relativity theory to have another sip of water. Thank goodness. As for foundations of intersubjectivity, they're certainly there throughout Kant's critical philosophy. I've subsequently published a piece on this that really underscores some of the central but neglected relations between Kant's and Aristotle's moral theory on just these points, because Kant actually is quite clear that we can only come to use whatever are our innate cognitive capacities through education and upbringing. And these are central to our becoming morally competent adults. And the intersubjectivity is there at the beginning of any issues about moral philosophy, comprehensively speaking, because we do have the capacity to decide what to do or what not to do, and we are thus obligated to consider how what we decide to do or not to do may or may not affect ourselves or others in morally relevant ways. And that social aspect to individual decision and action is there from the start and is only augmented by Kant's recognition that, like Aristotle, we are mutually interdependent for our reaching enough maturity even to be worried about whether or not we can steal something from the dime store. The answer is no. So the fact of reason that seems like such a surprise for Kant to appeal to in the second critique, I think, is not any kind of relapse into intuitionism, as it's sometimes been portrayed, and really is acknowledging what he had already set out about the rational autonomy of judgment in the first critique. About recognizing others as free rational agents, it's quite surprising what he says in two places. One is in the Doctrine of Method in the first critique, and again in the remark, the long general remark after 46 of the third critique, section 46 of the third critique. He makes exactly the same argument, essentially by analogy. And it's exactly when we see some organism behaving in ways which are purposive and which cannot be explained by appeal to natural laws, that's exactly when we're entitled to ascribe to that organism not only sensibility, but also understanding and reason. A surprising argument if you don't read enough of Kant's actual critical corpus. I actually think he's quite right, but Kant isn't himself quite yet a hermeneutical philosopher, but oh, he's right there. And it really does have to do with how we understand one another to be sufficiently intelligent agents to deal with one another. And then there are those pathological cases where we realize, no, this is not a competent human being, and we need either to protect ourselves or put this person under professional supervision for her or his own good. Better that than elect them to high office. Okay, thank you.
Let's move south of Serbia.
All moral philosophy rests entirely on its pure part, and applied to the human being, it does not borrow the least thing from our acquaintance with him, anthropology, but gives him as a rational being laws a priori, which of course still require a power of judgment sharpened by experience, partly to distinguish in what cases they are applicable, partly to obtain for them access to the will of a human being and momentum for performance. Now this applicability has always been a point of interest for me when it comes to Kant. For example, if I was to formulate a maxim saying I will dedicate my life to philosophy, what would happen if all human beings or all rational beings would accept that maxim? What would happen if that maxim would become universal? Well, frankly, we would all die of hunger because no one would produce food. And if we assume that the practical law is applicable to this maxim, then we would consider that maxim immoral, or for that matter, almost every maxim concerning professional choice. However, we see how absurd that is. We see that the division of labor is somehow excluded from the domain of the practical law. And well, Kant, in the preface, when he says that we still require a power of judgment sharpened by experience, he practically says nothing more specific of it. He leaves the reader practically to her own resources. But I believe that there are certain points, there are certain passages in the groundwork that can serve as hints as to what Kant thinks this experience, this relevant experience, might consist of, or what it might point to. Well, the first obvious candidate is the assertoric imperative, where Kant says there is one end that can be presupposed as actual in all rational beings, and thus one purpose in dependent finite rational beings, one purpose that they not merely can have, but that one can safely presuppose that one and all actually do have according to a natural necessity, and that is the purpose of happiness. One must present the assertoric imperative as necessary, not merely to some uncertain, merely possible purpose, but to a purpose that one can presuppose safely and a priori in every human being, because it belongs to its essence. Now, the essence of the human being that Kant is talking here is not the human being's rational nominal essence, but his empirical essence, dependent finite being. And that leads us actually to the second passage, the second hint that Kant may provide to what is the relevant experience that sharpens our power of judgment, and that's the imperfect duties to oneself and to others, the development of my own talents and helping others that are in trouble. Developing my own talents is, well, the imperfect duties are quite, well, Kant provides quite poor arguments for them in the very text of the groundwork, because it's not obvious if Kant refers to the purposes that we have as rational beings or as empirical beings. He says, I should develop my talents because my talents can be very useful for me to achieve my purposes. But that can be an argument of prudence as well as an argument of morality. And I believe that Kant intends to make a relevant difference here between the argument of prudence and the argument of morality, or the imperfect duties toward others. If we make it a universal rule that everyone should help everyone else when they are in trouble, then it is prudent for me to act upon such maxim, because I might get in trouble myself. But that's a prudent argument. In order to make a moral argument out of that, we would have to have a certain notion of what it actually means to have a purpose as a rational being and not as a finite being. Now, what Kant says here, that obviously empirical experience is of no help here, because empirical experience can only lead to generality, and his criticism of the concept of happiness as well as empiricism in general is that, well, empiricism attains generality at best. But Kant never says that that generality can be discarded as useless, because the general knowledge is actually part of this relevant experience that sharpens our power of judgment. And where can we see this? If Kant dismisses general knowledge, he puts himself in a very, very old trouble, a trouble that bothers Stoics or Cynics, and that's the trouble of, well, if we say that property, if we say that goods have no values, if we say that property isn't a proper good, then how do we justify that theft is a crime? If we say that, well, life itself isn't a good, then why is murder a crime? Why is it bad to kill or to rob, etc.? So we can say that they are preferred in difference, but that's only begging the question, preferred as what exactly? So Kant needs this empirical generality in order to have, well, at least a principal scope of what it is to help others and what it is to develop our talents, what it is to have a purpose at all as a finite dependent being. But when it comes to noumenal beings and their purposes, what can be actually counted? What can we use to describe noumenal beings? Here I'd like to refer to a few comments made by Terence Irvin in his Development of Ethics. I find Irvin's arguments in general very, very provocative, and some of them may present a challenge for the constructivist view. Some of his comments can be well incorporated in your conception, and some might take some effort in order to put them in line with your conception. But most of them are very provoking, very inspiring, at least they were for me. First, Irvin asks if we can attribute the realist view to Kant. He thinks that there are certainly passages in the groundwork and the critique and the metaphysics of morals that can, well, bring it to question that Kant is even trying to provide a realist account. So he says, Kant's claims that moral beliefs are practical, and one might infer that they express a point of view we take for practical purposes and not a source of true beliefs about any independent reality. In the groundwork, he maintains that every being which cannot act in any other way than under the idea of freedom is for this very reason free from a practical point of view. So perhaps moral theory tells us that the ideas under which we must act without giving us a reason to believe in any moral reality. But Irvin doesn't believe that this is a persuasive point. Terence Irvin, yeah. Because this is what he says. This reconstruction of Kant rests on two assumptions. First assumption, he's right to claim that a phenomenal world described by empirical science leaves no room for moral truths. And second assumption, his attempt to describe a noumenal reality that moral truths are about is hopelessly flawed. And each assumption is actually doubtful, because his introduction of noumenal reality, even in the first critique, serves to make room for beliefs and for moral beliefs. If our moral beliefs did not claim to be about objective reality, then Kant would have no reason to introduce subjective noumenal properties. Now, the second commentary linked to this one insists on a difference between legislation, being a legislator, and being an author of the law. And Kant makes this clear distinction in the Metaphysics of Morals. Here's a quote. A law, a morally practical law, is a proposition which contains a categorical imperative, a command. He who commands through a law is the lawgiver, the legislator. He is the author of the obligation in accordance with the law, but he is not always the author of the law. If he were so, the law would be positive, contingent, and arbitrary, willkürlich. So in making this distinction between the legislator and the author of the law, if we want to make the law non-arbitrary, then our will, if our will is the one that is imposing the law upon us, mustn't be the author of the law. So what Irvin actually is trying to say, if I understand he's in your position, is what we do construct is not the law, it is the obligation. It is that feeling that I must obey. It is the answer to the question, why would I listen? Why would I obey the categorical imperative? So the will imposes the obligation of the law and does not decide what the moral law is to be, but only chooses whether or not to accept it. And the concept of autonomy that is implied by this distinction of the legislation and the author of the law, the concept of autonomy is, well, practically it's in line with traditional naturalistic concept of autonomy, or so Irwin claims, because what Irwin thinks that Kant is, what his point of critique against naturalism is only empiricism, and not their concept of autonomy. The concept of autonomy, if we take this distinction, and Kant isn't always consistent with the use of, with making the distinction between legislature and being the author of the law. In the groundwork, he confuses them, but yeah, the groundwork is I mean, one of the most relaxed Kant's works. So he probably uses the term legislation in a more loose sense there. He is, in most places, he is very consistent that we must not be the author of the law unless the law is to be arbitrary and to be positive, etc. But another point about the autonomy here, and another point about the importance of this distinction, is that Kant avoids the Pyrrhonian dilemma of the criterion, or at least he does so according to Irwin's account, if we make this difference. Here's a quote from Irwin. If we were to claim that practical reason makes the moral law a law because of its act of declaring the law, we would make the moral law a special kind of positive law. We would then have to postulate a further moral law that authorizes practical reason to legislate. This further moral law could not itself be made law by some act of practical reason. Practical reason, therefore, can declare a moral law only by recognizing some law that exists apart from acts of declaration. I think that is, in fact, consistent with your position, that the point you make about Hume, for example, that we already take the social practices and the institutions, and then we make them into law. And the final point is the question whether this concept of autonomy is in line with Kant's dedication to enlightenment. If we take that autonomy isn't the ability of the will to give itself law, to be the author of its own law, but only to choose what it enforces upon oneself, then it is consistent with Kant's dedication to enlightenment, because the autonomy decides according to its own reasons and not any external imposed authority on itself, what it is to impose on itself. So to be the author of the content of the law is not required for Kant's position to be, to remain dedicated to enlightenment. Thank you.
Again, thank you very much for the comments and the passages, and for mentioning Terry Irwin, who's one of the people who I think focuses too much on ethics and not enough on moral philosophy. I think that when Irwin uses the phrase noumenal reality, he doesn't know what Kant's talking about. And I'm just going to let that one go at that. About the remarks you pull out concerning autonomy and the Enlightenment and what Irwin is citing as grounds for ascribing a moral realism to Kant, we're agreed entirely that what Kant says we authorize are our own obligations to do as morality requires. We then have the question, what does morality require? And if we're not going to wind up in the war of all on all, whether verbally or worse, there will have to be some quite definite principles that, per the Euthyphro question, are obligatory for us as free rational agents, regardless of what we may otherwise think about it. And so on those counts, I'm entirely agreed with Irwin on those quite limited points on Kant's view. But I'm not at all happy with how he characterizes moral realism, because I think he's using the phrase all too loosely. And I was quite specific in saying, essentially rejecting notions about truth makers for moral claims, or varieties of what get thought of as Platonism about, or theological natural law theory. But I have not at any point said moral realism is incorrect. What I've argued is it's not necessary, one way or the other. Right? By design, this kind of natural law constructivism is consistent with, compatible with, at least the core of quite traditional natural law theory, whether it's Platonist or theological. And I'm very happy with that result. All right. Very happy with it. In fact, I now have, right, I've got doctoral students who are observant Muslims who realize that this is exactly why the neutrality about moral realism matters to what I'm doing. And they're writing on Kant and natural law constructivism and traditional, meaning earlier, Islamic natural law theory, right, from classical natural law tradition. It's fabulous. And partly because what comes out of Kant's account of autonomy and communicability is a fundamental requirement, and this is quite global, central to moral views and approaches of the world worldwide, right? Fundamental requirement of humility, right? Using the Ulpian formula, right? Harm no one, injure no one. That includes, do not impose your views on others, right? Now that's consistent with our identifying and thwarting or otherwise constraining identifiable actions that are unjust, right? Murder, mayhem, homicide, and so forth. But that duty of humility is a quite powerful constraint on legitimate actions, institutional, individual, collective, international. And I think that Kant is quite serious about that, and that he's right that it is central to what I here wanted to distinguish are sort of these two aspects of that period we call the Enlightenment, and that it has everything to do with the autonomy of reason and reasoning, and nothing to do with the kind of one-size-fits-all mentality that was used as a pretext for far too much imperialism. And I take it that's not particularly an issue right now for us here. I know it's still happening, right? That's Same damn mess, right? Now, about whether Kant is looking at us or regarding us as rational beings or empirical beings, the answer is both. And it's an extraordinarily interesting feature of our empirical nature that we happen to have the capacities to reason about what is happening and what ought to be happening and what we ought to be doing that we ought to be doing. So it's extremely important to Kant. On the one hand, yes, he wants to focus on what he regards as a critical metaphysics which consists in a priori principles. These are a priori principles he thinks he gets by analyzing a logically contingent, empirically given concept. In the moral philosophy, the concept is finite rational agent. But he insists from the groundwork through to the end that this set of critical principles, whether regarding theoretical knowledge or regarding morals, requires for its application to us a practical anthropology. And so, and in this connection, in exactly this connection in the metaphysics of morals, he says the metaphysics of morals is not a complete ethics. For that, we need to bring in the practical anthropology and actually sort out what are our human flesh and blood duties and permissions and prohibitions. And it will be in those connections then, as finite rational agents, that we wind up having identifiable duties of mutual aid and to develop our own talents. Now, about the division of labor, yes, and the various forms of divisions of labor, Kant has, I think, unfortunately little to tell us. But the most general issue that your comments touch on concerning division of labor and our avoiding dysfunctionally lopsided divisions of labor, I think Kant can handle that. And I went through this at some point in chapter 6 about coordination maxims, right? There's all kinds of permissible elective actions that, if they're universalized across groups, would indeed cause major problems, right? We just completely exceed the capacities of our resources. And so we can be quite happy that we do, for natural and other and social reasons, develop different interests and capacities and useful forms, often very useful forms, of divisions of labor. Those will all be, on Kant's view, insofar as they're legitimate, permissible forms of activity, individually and institutionally. And yes, if we take some of those kinds of maxims and run them through overly simplistic universalizability tests, it looks like we wind up with problems. But I think those are problems of mistaking Kant's actual universalizability procedure and requirements. And that has been all too chronic, especially by Kant's critics, but not only. And issues about coordination maxims were discussed already by Honora Neal in her first book, and also by Barbara Herman. And I don't have anything to add to them except to restate how that fits with his criteria. So I don't think I have, and I don't think I need to have anything new to add to that. So I'll just remind you of that part. Does that help enough? I mean, you're right. I mean, once we get into, sort of flesh and blood issues about human production and reproduction and economics, we have a lot of quite specific social planning, procedures, principles, designations, and division of labor to deal with. And what's curious actually about the Hegel is that in line with traditional natural law theory, Hegel too is impressed with the extent to which human beings in actually conducting their social lives often exhibit far more credible and far better informed versions of rational planning than you get off of philosophers' drawing boards. And this is why, first, to take Kant's critical principles and then actually develop the full-fledged ethical theory and moral philosophy, not just the metaphysics of morals, but moral philosophy, and to do so in ways that provide determinate answers to what we ought to do and ought not do and what we may do. Hegel brings in not only large doses of what Kant, or large measures of what Kant wants to call practical anthropology, but also an enormous amount of political economy in ways that also Sidgwick did, I'm sure without knowing that Hegel had been doing that. And so in those connections, what Hegel wants to do is recognize that, of course, in our daily lives, we do coordinate our activities, we do find ways of meeting our needs, and what we need are principles and procedures for monitoring what we are doing and monitoring unintended consequences of collective forms of action, and monitoring the extent to which the intended and the unintended consequences of our social and commercial and economic activities either support or thwart everybody's legitimate claims to proper membership within society, everyone's proper Republican citizenship, and criteria for evaluating when we have to fix some of our procedures in order to rectify injustices or imminent results that will be unjust unless we take proper corrective measures in advance. And that, I think, is really what Hegel's done in the Philosophy of Right. Now, that's a wildly heterodox reading of Hegel, I know that. But that book's almost done. It's the second installment on natural law constructivism. I hope that's some help with the questions you raised, but thank you for those.
We have some 5-10 minutes until the coffee break, coffee to be ready. So I would like to just take the opportunity because you mentioned republicanism and you wrote about it on a few pages at the end of the book.
Yes.
So I would like to know how we can identify basic rights and obligations of Republican citizenship based on Kantian's theory that you are defending. Because republicanism is not only about negative rights, what it calls right to non-domination.
Right.
Yes, at Kant, I think that you connected it with his notion of freedom, of innate soul, account of freedom.
Yes.
Yeah. So can you tell us a little bit about it and about the connection between republicanism and democracy? Because you are also a critic of democracy, as I understood you in Istanbul when we had a talk.
Well, I'm certainly a critic of what's been made of democracy. I mean, democracy is a great idea. I'd like to have some.
I remember the times when the word socialism used to be a very good and nice word.
Right.
Now it's not. And before that, some other people knew that fascism was a solidarity and
Right.
things like that. But now it's very ugly war. So is democracy going in the same direction? The war, I think.
Yes. Yeah, on rights to, on Republican rights to citizenship and the positive rights that those involve, as well as duties, I'll in fact have a fair amount to say tomorrow. So I will come back to that. And Kant has more to say about them than he's often credited with, and yet not as much as most of us would wish. He certainly has some quite direct things to say about, acceptable, permissible forms of taxation, and about public obligations for at least some forms of social services for health care, and he also mentions foundling hospitals, right, for orphans or abandoned infants. And, he's understandably cautious about how much he's going to suggest in print in his day and age, but I think the principles that he develops really have quite strong implications for, I'm going to say, participatory republicanism, right? That Hegel is absolutely right that these principles require that everyone be provided the effective opportunities actually to be and to be recognized as a fellow citizen in good standing. All right, he's crystal clear about that benchmark in print, in the Grundlinien. And he's crystal clear that that is a relative standard. It's not a benchmark of mere subsistence, so that it is providing sufficient opportunities and social resources to either avoid or to counteract varieties of mishaps, including economic mishaps, that can reduce people to poverty and threaten to reduce them below the level of actual and recognized, and I'm conjoining those on purpose, active citizenship within society. And I think that that comes through quite clearly from these kinds of principles. So, yes, the first line of complaint about democracy is an old one, an ancient one, in fact, and that is the tendencies of democracies to become tyrannies of the majority or of the vocal minority. And all kinds of ways have been found in the last centuries to facilitate those developments rather than counteract them in many parts of the world. If I could have moved to Canada, I would have been happy to a long time ago. Right? Go just even a little bit north of the northern US border, and suddenly you're in civilization again. And it, in many ways, is remarkable because it has been really such an effective transformation of what had been, a monarchical Commonwealth country into, in many regards, a pretty damn functional republic. Obviously not without its problems. This is what politics is about, trying to identify and deal with our problems. So yes, I'm joining forces such as I can with people like Pettit and Forrest and so on, who are trying to regenerate the Republican inclusiveness without which democracy isn't a legitimate form of government. And, you know, also in this, of course, is overt and covert criticism of the notion that democracy is just a bunch of aggregation of preferences, that the public office of citizen is in fact one that has enormous responsibilities, and those responsibilities are being more and more thwarted by mass media that is just a glut of distraction. And, you know, here I can speak a little more freely about the country in which I'm now living, where all of these deteriorations are happening at a frightening pace. We shall see what happens in the next few years. I hope it remains peaceable enough and that enough academic freedom is preserved that I can continue teaching there. Because aside from the politics, I'm having a fabulous time in Istanbul and with my colleagues and students at Boğaziçi. But, you know, we're all sort of on notice, wondering when the political winds are going to turn into a tempest. And we don't know.
What kind of dictatorship is that? It's not the majority. It's more like the prejudices that you described here with Greenspan case. He is a dictator of a kind with a group.
Yes.
Transforming the prejudices into ideology, which became maybe accidentally, maybe not, a ruling ideology.
Mm-hmm.
And it's kind of dictator.
Yes.
Much more than those European monarchies in Scandinavia.
Oh, yeah, no,
kings.
completely, yeah. Well, officially they're monarchies. I mean, in fact, they're the closest thing to Hegel's political recommendations in the Grundlinjen there is. And it's not an accident, because it was a student of Hegel's who took this back to Finland, right? Johan Snellman. And he became not only a staunch critic of Swedish rule, and indeed was kept out of academia for a long time. He couldn't get an academic appointment. But once Finland was established as its own republic, he was central to its polities and politics, and also was Chancellor of the Exchequer. That is to say, he was the chief financial minister for years in Finland. And yes, Finland too is having its right-wing uprising, but what modern Finland has been as a republic indeed is quite directly indebted to Hegel's Grundlinjen, and Snellman having taken them back with him to Finland and managing actually to institutionalize them. And Finland has, in those regards, often been a model for the Scandinavian and Nordic countries.
Institutionalized responsibility.
Right.
In a way.
Yes.
Okay, great. Let's have a coffee.
Thank you, Rasko. I would like to raise several issues. First, it just happened that we talked about something that I wanted to start with, ethics and justice as a kind of division. But I may put that for the later, comply with the dictates of justice and some other comments and questions. I would like to say at the outset that I liked very much your interpreting, or some might say reinterpreting of Hume. Actually, I don't think it's reinterpreting of Hume stricto sensu, but it might be perceived as such, because it's not the usual interpretation, because you put the focus on something that is not the sense but the principles, and it's the issue of nominalism. It's the matter that, as you have on 62, page 62, that Hume analysis of justice shows that certain actions are just or unjust, regardless of any agent's motives or preferences, and regardless of any observer's sentiments. But the issue how to come to that, how to achieve that, you, I think, have to have the position that Hume has, that's radical nominalism, which is not going to justification of particular actions as such, but the aiming to give the predictability as the main reason for justice is to make society as such functional. So that's something that is very, let me go to, that confirmed, corroborated at the end.
Well, fidelity to promise and contract is all about predictability, yes.
Yes, but fidelity could be attained only if you stick to the contracts, yes. Not to reconsider every contract each time from anew, because someone might look it differently and find some small, or maybe not always small, problematic issue there. So that's the main issue. Yes. On the other side, what we share is the Kantian approach to the philosophy and to the reality and to the life, actually. And you showed very nicely how Kant is relying on Hume and Hobbes, and not on Locke, obviously. Finding the basis for all that, surprisingly, may be from the Humean point of view, in freedom, which is the power to make decisions. And the problem there is that making the decision, you presuppose some kind of identity, presumably personal identity, but may not only personal, it could be collective identity, corporations, nations, maybe ideologies or civilizations. And there's an obvious problem there, because the moral aspect of the worth of freedom is respect, universal respect, which is something that is a reflexive kind of relation. I cannot respect myself without respecting others, and vice versa, which per implication forbids me to decide for others. That's a very basic principle, I think. We are not allowed to decide for others anytime, in whatever, because it would be disrespect for the autonomy of others. So if you should influence the behavior of others, you are not supposed to make any kind of orders or commands, but only put some restrictions. That's the issue there. To make cooperation, which Hume is interested in, possible or morally valuable, means that you have to, if you want to preserve the sanctity of the personhood of others, respect for the autonomy of the others and their freedom, you have to put some restrictions of the freedom. Possession is a very fine example of therein. And I would like to make a comment here, if you don't mind. What I think is the issue in possession and property is something very simple. Persons are having the right to use things, including themselves as things, not as persons, for whichever purpose they deem to be needed. So persons are giving to things a value by using them. And that's the basic starting point for possession. We are enacting or producing, creating the value of a thing by using it. And that usage should be predictable as well as the other issues there. Creating rules, and maxims are already rules, and we cannot avoid the rules part anyway. We cannot approach the substance of the reality in a way other than schematic. So we having the right to possess a thing. You had a very fine example. You don't possess the glass because glass already has been possessed. But not only possessed, it's ownership of the institute. So possession should be protected by an institution, which shows that ownership is more than pure possession. But nevertheless, the possession is the most important basic part. Ownership is only a kind of additional protection of the possession. Which possession? That possession that is rightful and legitimate. So you had, in some way, in your writings, the example of a stick lying next to the trail, and being tired or whatever, you take that stick. But you may like the stick and use it for some time. I wouldn't have the right to tell you, so you had it some time, now it's my turn. Or you may even bring that stick home and it will be your possession. Will it become a property in the way of ownership? It's questionable. But if we imagine that that stick proved to be something very valuable, something that is not just a thing waiting to be used, but something which is its inherent value, out of sudden my right to take it disappears. Why? Because the value perceived therein have to be established at some prior time. So it's not a thing waiting to be used. It's a thing that already obtained its value. In a way. That's the logic that makes the possession that basic for the predictability and for the rules. So justice and society must rely on some very stable rules that are there to make predictability really working, not to be interrupted accidentally and gratuitously or whatever that. Yeah. So that's the point, I think the main point in your book, and that's that being arbitrary, being artificial doesn't imply to being arbitrary. That's the basic point. Okay. So I would like to further to make some remarks regarding your lecture at the beginning. You followed the book in explicating the distinction between moral motivation and moral justification, and the differences between justification, explanation, and that's all interesting. But at one point you specified it as injure no one. So that's where morality, as it seems, resides. It's more than sufficient. You said that that's sufficient reason for an action, but later specified it. It's not sufficient reason for any action. It's a sufficient reason for a permissible or legitimate action, that action that could go through the test of not deciding for others. We may say that we are deciding in a negative way, indirectly, for others by making restrictions, but that's the point. That it has to remain to be indirect, never to become direct. So that's the main part of categorical imperative, I think. So that's where moral justification differs from a justification of an action as such. Any action has or has to have a justification in a reason being there extant for that action, in a purpose of an end that someone has set for himself and trying to realize that. That's what makes the difference between actions and events. Action has to be an event, not only something that is imagined or conceived, but something really done. So actions are events, but not merely events, not events that they are based in a decision. And they are justified in a prima facie sense by there being that reason, for that reason being in the end that has been set and then tried to realize. But that might not be some immoral or illegitimate end. And we have that very, how to say that, very vividly visible in, let's say, in analyzing the word good. Good is not a moral term. A good poison or a good poisoner is not necessarily a morally laudatory thing. So the action as such is justified in the end that has been set, that someone has set and tried to. But that's not enough for the moral justification. And moral justification is asking something additional to put there. But if we remember that we are not allowed to decide for others at all, it must be only a kind of restriction. So I'm coming back now to Kant, and my own approach is something that I call via negativa. Morality is dealing only with restrictions. It only forbids. It doesn't command anything. Why? Because the freedom is full anyway, all the time. We are free even to break the laws or be immoral. That's only one condition to become a criminal, for example. You just have to want it. But that's the issue of imputability of responsibility. So if we differentiate morality from issuing commands, we would, in my opinion, have really a pure Kantian approach. And many of those issues that are like division of labor, etc., would disappear because we would say that's the realm, the domain of happiness. It's up to us to decide whatever we want, on condition that what we want is legitimate and permissible. Morality is dealing only with what's permissible, with limits, with the other side of that domain. So that's where the moral justification differs from justification of any act as such. The ignorance plays a very interesting, and you mentioned that in your lecture, very interesting, a very important role there, and that's the point where Kant comes close to Hobbes. You said explicitly, ignorance is producing natural order very easily, spontaneously, in a way. So we have that order, natural order, here, now, around us, at least latently, but very often also very much actually. And that's why justice must be public and known. It has to be known, not just proclaimed and existing somewhere hidden. But known here on the intersubjective level means shared. Yeah, shared, being common. Shared sense of justice is producing intersubjectivity or intersubjective identification in the same way in which Hobbesian psychological egoism is producing the unity of person, not some, what's the term? I mentioned that, dividing person in many. Help me. The term when you have the illness, divided persons. One word. Schizophrenic. Yeah. A schizophrenic person wouldn't be a unified person. So we have the Platonic or Aristotelian unity of the soul, making possible planning, predicting, acting, deciding, intending, thinking, anything. Everything is dependable on that supposition of the unity of the soul, of identity. And shared sense of justice is producing the same on the level of the society. Less efficiently, less thick, etc. But the function is pretty much the same. So that's very much shown here in the book. I could, in the end, perhaps just say a little bit more about, or raise some specific questions. First, that's very at the very beginning, at the very outset of the book, you said that okay, ethics and justice, it's okay, but because one of our most basic ethical duties is comply with dictates of justice. It's very much true, but not really clearly what's said here. On the other way, somewhere very late on page 100, you quote Kant saying, "Freedom is the sole original right belonging to everyone by virtue of being human freedom." And then that's 196. Freedom is the sole original right belonging to everyone by virtue of being human. Again, human is a specification. It might be perhaps robots or extraterrestrials, which are not human, might be. But it's clear what's here. And then on page 201, you introduce the issue of a need for mature judgment. And it might look that on the bottom line in Kant, you would have in the end only one basic duty, and that's the duty to think seriously. and everything would follow that.
Only to act on the basis of justifiable
Yeah.
principles.
But that's what we all have by virtue of being what we are. So in a way, we are producing ourselves by thinking, either as villains or virtuous person, or whatever we become in the end. But that's something that is the major judgment is the condition of the responsibility every way. So when you, for example, when you say basic principles of justice are required to form and maintain society, which is indispensable for the human life, that's intersubjective, collective level, and then corroborated that issue of nominalism, implying that for the rules to be functionable, we have to restrict ourselves on the formal aspect of that, and not to go to consider every act per se. And that's the issue of the predictability. But predictability is corroborating and confirming actually the capacity of freedom, which is the rule of the future time. It's overcoming the next point in the time, which means overcoming the causality, because we set the end somewhere in the future. The end doesn't exist. It's only in our conceiving power. But the freedom is the capacity to find the means to produce that end by finding some causes that would produce that end as a consequence. So that's connecting knowledge and predictability and unification of the soul and identity, and all that is actually functioning on the collective level of as well. And that depends on the issue that it's regardless of the particular motives and desires and preferences. Otherwise it couldn't function. So double bookkeeping, or the issues that let me just find what I put here. The issues were economy, the issues how Greenspan became a dictator without being elected at all, and, or being elected in a very odd way, not elected by those on whose behalf he was acting and whose lives were affected. Right. Yeah. But all that is actually with that maturity and serious thinking issue. So in a way, it's very not comprehensive, but coherent and overarching position. It seems to be going in a way to very basic, but in the way that basic is what everything else is based in. Okay, let me only raise a few questions, not exegetic, but maybe terminological. On page 10, you have that nominal, and I now grasped why in the discussion and the lecture why you put the nominal, why you equalize nominal with normative in a way. I, for myself, always took nominal as an important tenet in transcendental approach, meaning that we are fallible, we cannot, we don't have the the access to essences, empirical approach to the reality is the only one available to us, but it's not perfect, not good enough, etc. So nominal used to me as a principle that should show why we, let's say, simplistically put epistemology in front of ontology. And regarding other issues that if we don't keep that all the time in our mind, we became essentialists, which means that we make conclusions that are not necessarily based in the premises, which is something that transcendentalism is avoiding. But here you are connecting nominal with normative matters. Regarding that, I have the following question. Normative matters are the matters of norms. But norms, or formulating norms, are also something from within the capacity of freedom we make. We are normative always when we are free, because we are setting ends. But upon realizing those ends are becoming the part of actual reality, and there is nothing more, nothing normative longer there. It's the effects of that. So the institutional facts, which are the real consequence of our, they are facts. They are factual in a way in which natural facts are not. Yeah. They are much harder, much stricter kind of facts. The fact that I am married is much stricter than the fact that it is, let's say, hard. It's hard for me, but if I am a very strong robot, it wouldn't be hard. Yeah. So, how far are you prepared or will to go with this equalizing nominal with normative?
Thank you very, very much for your comments and questions and remarks. And I'm really delighted that you understood what I was doing so well. And apparently we have quite a good deal of common theoretical moral ground here. And it's a great pleasure to me. So thank you. Thank you very much. Let me start with the last one first about normativity and the noumenal. I do stand by what I say there, that all normative matters as such are noumenal for the reason I indicate. That is, their empirical specifics will never suffice to identify the normative status, whether we're talking about principles or actions or consequences. You know, I always have fun pointing this one out to my students in, you know, introductory class, talking about Kant's ethics, right? Here's the situation, right? You enter a park, you see one person racing away as fast as he can run with a fistful of money, and you see another guy chasing him, and you can catch one of them. Which one do you pick? You can't tell, right? You don't know whether it's the thief in the lead escaping with the money he's just stolen, or it's the rightful owner of the money who just recovered his funds and are now being chased by the thief, right?
You know, just seeing this mad chase doesn't suffice to tell us who's the rightful owner, if anyone, of that money. So freedom certainly does reside in setting ends, but also in the responsibility to set those ends that we ought and not to set those ends that we ought not, right? So that level of normativity is there every time we have issues about action.
But both aspects of the freedom are always present.
Yes, 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 entirely. And so that's enough for these issues about freedom, about ends, and about responsibilities to count in Kant's lexicon as noumenal. And this simply has nothing to do with the metaphysics of transcendental idealism. All right? Okay, but I'm just mentioning that again because too often, particularly by Anglophones, Kant's referral to noumena in connection with principles of justice has just completely derailed commentators. All right? And likewise, his talk about, you know, rights to possession being intelligible. Well, yes, but for just the reasons we've been talking about. And, you know, I think it's sort of excess remnants of empiricism that have led so many Anglophones to misunderstand what Kant is actually talking about here. That and enormous neglect of almost all the natural law tradition. Right. I mean, one of the reasons why this has been much less often misunderstood in Europe, particularly in Germany, is that, you know, moral philosophers in Germany, certainly, but not only, it's pretty common in Europe, remain alert to the long tradition of natural law theory. And it matters a lot to how we understand what we're doing as moral philosophies and within moral philosophy, or as moral philosophers and within moral philosophy. Yes, it is a surprise what we can get out of Hume if we read very carefully what he's actually saying about the conventions that get woven together into the most fundamental rules of justice. And they really do have to do with principles and with deciding to act on the basis of those principles and practices, and the issues about regularity and predictability. And in this regard, I mean, Kant didn't know this because he didn't know political economy, but it was Hume's writings on economics that launched Scott's political economy. And this, again, is part of where Hegel is capitalizing on political economy as a moral science, because issues about coordination and issues about how can we meet our ends and needs, our legitimate ends and needs at all, and then in addition, the strategic question, how can we do so efficiently and reliably? Well, we've been solving these problems as a species in all sorts of ways for as long as we've been around, right? I mean, this is exactly why there's more reason involved in customary forms of action than rationalists or empiricists were willing to recognize. And it's Hegel who looks at the results of modern political economy and realizes these practices are structured in ways, and they are structured in ways that we have in fact made for ourselves. And they, by developing these practices, including the entirety of the economy, we, on a daily basis, solve problems of basic human existence. Better or worse. The point right now is just that we do this, and then the question is, to what extent or in which regards do we do so legitimately, permissibly, as you say, with the via negativa? And so Hegel, in particular, bringing these Kantian principles and criteria to bear within a much richer moral philosophy on purpose, is looking at the ways in which customary forms and even habitual forms of action integrate reason and habit and inclination in ways that Hume and Kant failed adequately to appreciate. So partly, right, it's Kant's principle of hypothetical imperatives, right, strategic rationality that provides ample, I will say, prima facie justification for doing things in customary ways, right? Because they can be efficient, right? The procedures, the resources, the forms of interaction are established. That's not a trivial requirement. That's not a trivial achievement.
But not moral.
No, 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 no. Nothing about that is yet moral. But then we have issues.
Economy, happiness, politics,
Right.
everyday life.
Yes, right. So far, all I'm doing is elaborating more of what's still in Chapter 5 on Hume. But then we can get into issues very readily on the basis of these kinds of principles of economics and, of course, the legal principles that any even moderately sized economy quickly brings in tow, right? I mean, once we can no longer conduct all of our business, literally our business, on a face-to-face basis, then we start needing contract and law. And this is not news, right? I mean, there has been contract law back to Babylon, right? That was why they were so excited to find the Hammurabic Code in 1901-02. Well, they knew of it, but they got the stone with the massive inscription rediscovered 1901-2. And it was immediately translated into all the modern languages, twice into English. And, you know, comparative lawyers were reading that internationally as soon as they had it. And, you know, it's just not a surprise, right? There have been, you know, far-flung economies for as long as we have human records. And evidence, clear evidence of, you know, pre-recorded history, far-flung economies, right? I don't know whether you've caught up with this discovery, this enormous monument at Göbekli Tepe, which it's this elaborate monument like a Stonehenge, but much older, carefully wrought, carefully designed, and then after its building, and nobody yet knows why, completely buried. Now, just finding the structure indicates that there was an enormous capacity for coordinated, sustained, long-term social cooperation, and with enough excess resources that they could devote time and energy and materials to building this enormous monument, and then to devote to burying it. It's astounding. It's truly astounding. So, you know, the records go back thousands and thousands and thousands. I mean, the evidence of large-scale economic coordination is prehistoric at this point. All right. So now, this hasn't has raised any issues about justice. And, well, we know that the requirements of justice are quite severe, and they count severely against an awful lot of our current economic and political activities.
Our current economic and political activities are actually showing that we are living in natural order, in part.
Yes. Yes.
The issue here is the natural order in a way necessary, not only to be latent, but in part always has. There is no perfect reality. You mentioned that we are
Right.
perfectionists
Right.
outside of any reach or viable reach.
So part of my concern that comes out at the end of this book, and about which I'm saying more in current work, is just try to at least begin to raise some of the issues about how we've allowed what could be much more representative forms of much more Republican forms of democracy slide into the kind of mass manipulation of voting that it's become in too many countries. And what I've now managed to trace is the really quite long-term development of current academic crises, right? What's happened by constraints of budgets and managerial takeovers has become quite acute across the Occident, and yet the forewarnings of these kinds of developments began not later than 1860 with Mill's inaugural address in Edinburgh, and echoed only a very few years later in Wien by Arens in his Naturrecht. In the preface to the 6th edition, the closing pages are a quite blunt, forthright forewarning of what is going wrong with higher education and its neglect of a sufficiently comprehensive education so that people can understand and assess what they're doing in view of all of its ramifications for society and not just for their factional interests. And Aaron sees in 1867 just, you know, what is Europe tending towards? All right, he sees it crystal clear. Now, I don't think he's got a terribly viable Naturrecht theory, but that's an independent issue. You know, he sees why it matters. He sees what's gone wrong with the education, that the specialization and professionalization in education, including law, is tending to exactly the kind of centripetal fragmentation of studies and of life and of professionalization that's going to be a collective social disaster in short order. Right? Aaron sees that. Yes. 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 And I've put it on my website. I've got about 24 entries in a chronological order of quite clear-headed, informed, specific forewarnings of this decline of education away from the kind of comprehensive general education or liberal arts education, right? The education required to be a free citizen, right? That's what the liberal and liberal arts came from. The slide away from that kind of liberal education into specialized professionalism and technical disciplines. So there's one. And then I've got, what's happened to Anglophone ethics in the 20th century, about which I'll have more to say in the next book. And likely also what happens with economics, how economics shifts from political economy, and political economy conceived as a normative discipline, not only as a social science, how that gets left aside only to focus on the most technical aspects of micro and macroeconomic analysis. And I'm sorry, but the preliminary indications are both of these are quite direct results of a highly ideological, individualist, supposedly liberal center making its case against what it wanted to abuse as fascism of the right or left wing. Witness all the debate about methodological individualism in the social sciences through particularly the Cold War period. And experts in social science knew very well that this was a methodological principle only. It was not a substantive claim about whether human beings are fundamentally social or not. And Schumpeter, for one, is crystal clear about this in 1908. And social scientists in the 50s, I'm not going to remember his first name, but a fellow named Goldstein and also May Broadbeck, prominent philosopher of science in the 50s, they saw it crystal clear, right? This point about methodological individualism is a particular approach to investigating and trying to explain sociologically as an explanatory science social phenomena. It's not a substantive issue about human nature and whether atomistic individualism is true or some kind of monolithic collectivism is true, or whether perhaps, by the way, might it not be the case that human beings and the groups to which we belong are mutually interdependent? And Schumpeter knew that we were. Hegel knew that we were. Hume knew that we were. Rousseau knew that we were. Aristotle knew that we were. So did Plato. Please reread the Laws at your first opportunity. And I've also found now, Dewey, who unsurprisingly got it from Hegel, but I found a wonderful book written by a fellow who had trained at Oxford but wound up in the government program at Harvard, a guy named Eliot, and only gives his first initials, being British of at least academic pedigree. And he writes a tremendously lucid analysis, publishes in about 1920, of the developments within politics and within jurisprudence and even the early phases of Italian fascism. And he sees exactly what's going wrong. And he sees that it's going wrong because it's already turned into this ideological debate between an atomistic center and monolithic collectivisms at the right or left wing. And he's saying, look, this is just false. And he introduces a different term. I believe the term he comes up with, it's not a very elegant term, so I'm not surprised it didn't catch on, but he calls it co-organization. But the view explicitly, he's using it as a designation. I can send you the book. He's explicitly using it as a designation for the phenomena of the mutual interdependence of groups and their members. Mutual interdependence for their existence and their characteristics. And he can see what's on the eve, right? This is after the First World War, and he sees the next one coming. There's no question about that. And part of what I've been doing with this kind of historical research is coming across the really quite alarming and deeply troubling phenomenon of finding during these very turbulent and crucial periods examples of absolutely lucid, clear-headed, cogent analysis, theoretical and practical both, of exactly what's going wrong and what are the mistakes and what are the dangers, and those analyses just getting lost in the ideological melee. Right? The weaknesses of Carl Schmitt's Verfassungslehre were known at the time. There's a brilliant review the next year by Hartung, and he sees exactly what's going wrong with Schmitt's Verfassungslehre and problems with German jurisprudence are in several articles are very clearly analyzed and criticized and explained all by Hermann Kantorowicz. And it's after reading those that I understand better how stuff like Carl Schmitt's could ever be regarded as serious jurisprudence. Because at the time, there's fabulous Rechtswissenschaft and philosophy of law at the time available from before and after the First World War, and it's just getting ignored. And yes, it looks all too much like what's going on right now in my own so-called homeland. Sorry to cast a pall over this, but I mean, right. The point is, this really is practical philosophy, right? And my students, particularly in Istanbul, all know that I'm not doing this merely because I find it theoretically interesting. I do. But they all know that this matters, and it matters literally on the streets, and I don't need to talk to them about current politics, right? There's nothing more I can add to what they already know. But they sure want the analytical tools for understanding what's gone off the rails.
Do you have an answer for the question why conservative German theories put so so much attention to education. For example, late 15 in Staatslehre, 1813, and most famously Heidegger in 1933. He speaks only about education in that year, where he was in rector.
Well, I'm no expert on Fichte, so I'm not going to say anything. But I'll remind you, I'm sure you know of this, in the latter 19th century, a professor of education, pedagogy, in Kiel, edited all of Hegel's comments and writings on education. Yes, Gustav Thaulau. 4 volumes. 4 volumes on education, Hegel wrote. I've got them, don't worry. Give them to you in the morning. And I mean, Heidegger's talking about education, but he's talking about education at a time when he and also people like Jaspers had hopes that the Nazis were going to actually act on what they kept claiming, namely that they were going to help, you know, really regenerate German culture. And there had been hopes, as I'm sure you do know, for Germany establishing an elite university that would really help promote German culture. Well, that's, of course, the last thing the Nazis were ever going to do. And beyond that, I'm sorry, I simply can't be much bothered by or impressed by whatever Heidegger might have said about education at that point.
No, I'm not impressed also.
Well, thank you. And thank you, Professor, for being here with us. So first of all, I must say that after reading your book, I was very convinced that the most fundamental moral problems are indeed problems of social coordination and problems concerned with the question of what kind of universal normative principle should we adopt for society. So my comments will revolve around this issue and the related concepts that you discuss, of course, justice, freedom, and property. And let me start with justice and property. What I find interesting, and forgive me if this is an oversimplification, but it's my general impression. What I find interesting is that if we compare Hume's and Kant's concepts of justice, it seems to me that they have a different relation to property. Namely, Hume's concept of justice is derived from property relations directly from the demand for more stable and regular property relations necessary for the preservation of society and for enjoying the benefits of it. On the other hand, Kant's concept of justice, at least according to the universal principle of justice formulated as you cite in your book, is formulated independently from property relations. It is instead derived from the concept of freedom. So it requires freedom of will to coexist with everyone's freedom in accord with the universal law. This principle is only subsequently applied to property. So Kant's concern is actually how to regulate property in order to preserve freedom in society. So it seems to me that whereas Hume's concept of justice is limited to property relations, Kant's concept is broader in that it concerns law in general as the guarantor of freedom in society. So I don't know if you agree with this, but if you do you think that this distinction between founding justice on property on the one hand, or founding property on a more fundamental concept of justice has any practical significance in terms of norms and principles that we adopt in our society? And let me clarify this and then go on to my next question. I think this issue becomes especially interesting if we consider the concept of social justice. Because on the one hand, demand for social justice is the demand for redistribution. It concerns property. It proposes that more equal distribution of property is more just. On the other hand, if we want to understand the reasons behind this demand regarding property, if we want to morally justify the demand for social justice, we have to go beyond simply stating that more equal distribution is more just. That is, we must go beyond property relations and into the realm of freedom. And this is where the previously mentioned distinction between Hume and Kant plays a role, I think. The distinction whether we base justice on the stability of property or derive it from freedom. Namely, if we think stability of property, property relations defines what is just, we can allow for a society in which grave inequalities exist. Because what matters is, in Nozick's words, that everybody is entitled to the holdings they possess under the distribution, that they acquire their holdings in a lawful way, and this is what justice means. It isn't concerned with inequalities and consequences of inequalities. On the other hand, I think Kant's conception can be used to justify social justice demands because it precisely appeals to human freedom, which is de facto endangered in the circumstances of grave inequalities. So, in light of this, my question is, do you think that social justice as a principle for society, or as the principle for society, is morally justifiable? And on what grounds, if yes? Should we appeal to basic needs? Should we redefine concept of property? These are all questions that come to my mind when I think about this. And especially because freedom, although it can be used to justify social justice policies, it can also be used to, like Nozick and Hayek use this argument, precisely to attack social justice policies and criticize them. So this ambiguity of justification in terms of freedom is part of my issues with this. So yes, that's it. I would like to hear your thoughts.
Okay, so let me first put in a small but important request. Don't let this out on the web.
I'll say enough to get myself in trouble in print soon enough. Let me say a number of things. I think so far as Hume develops his account of justice and of property rights, we're not going to be able to get very far with issues about social justice. And indeed, that was one of my points, is that there's not yet enough to the principles and the practices, much less to the justification of them, to get very far with issues about social justice. And so I think it's not a surprise that he had terribly little to say about the topic. Kant had somewhat more to say about the topic, not all of it satisfactory. At one point, this doesn't belong directly to what he regards as the main text of the Metaphysics of Morals in the section on justice. It's part of the quasi-empirical elaborations in his remarks that are indented. He makes this infamous distinction between active and passive citizens and says that it always must be allowed to be possible to work yourself up from the status of passive to an active citizen, where an active citizen has enough of his own income to be civilly independent, in contrast to laborers who have to seek employment from someone else and perhaps perform their services on somebody else's premises, right? Somebody else's land or home. And he is concerned, this part's at least legitimate, about how easily people in that kind of an economically dependent position might be coerced by their typical employers to vote in a certain way. Well, that's an issue, but it's not solved in the way Kant wants to. And of course, the other grand classification for passive citizens is, as he says, alles Frauenzimmer, right? Everything to do with women. And he doesn't stop to explain how anyone is supposed to be able to work her way up from the status of woman to the status of an independent citizen. And there can be no such explanation. So this isn't very helpful. But I do think that Kant's principles, and particularly the sole innate right to freedom, sets exactly the kinds of stringent benchmarks on socially acceptable disproportions of wealth, not opportunity, but wealth, that's indicated already by Rousseau. And that is, whatever may be the disproportions of wealth, they have to be kept within the limits whereby no one who's got the wealth can command unilaterally anybody else's decision or action. And Kant doesn't spell that out in his Metaphysical Elements of Justice, which I think is not too surprising. But Hegel knows that it's entailed by that sole innate right to freedom. And he knows that that entailment pops out as soon as you realize that we are interdependent beings and we are economically and socially interdependent beings. And you plug just those two premises together with the sole innate right to freedom, and the Rousseauian independence requirement falls out as a corollary, right? That the institutions and practices and procedures and legislation, as well as the unintended consequences of economic activity in terms of differentials in wealth or leisure, have to be kept within whatever limits and by whatever means enables everyone within society to participate and cooperate with others by his or her own independent choice, which requires the effective power not to engage in social activities or social coordination. All right, so this is going to directly rule out what Marx castigates as wage slavery, right? And Hegel is explicit about this, that once we've got an industrializing economy and a nation state that completely occupies a designated territory, and these are contiguously bounded nation states, everyone within that nation state is now denied access to uninhabited nature, by recourse to which an individual could, at least in principle, manage to survive. Once society has removed that prospect, and this happened a long time ago, every society owes it to everyone within that society that she or he be provided sufficient genuine opportunities to earn his or her livelihood. and to participate as a fully independent and recognized independent citizen in good standing, including political representation. Now, Hegel doesn't think we should do that by districts for very good reason, right? He realizes that district representation divides political from economic life and ensures that people will enter the voting booth disregarding the economic structure and the political structure of their own societies and disregarding the kinds of indirect, unintended consequences of economic activities that create exactly the kinds of miseries that we've been alluding to today. So that Hegel's system of political representation by corporations, where corporations are for each region and township and also church, but also for each sector of the economy, where the economic corporations include both management and labor, and the corporations are to provide representatives to the legislature, the lower house. But Hegel, by design, is trying to ensure that the entirety of the political economy is represented within the legislative process, so that people can know that the entirety of the political economy is being taken into account in legislation and protest when it's not, and that they have representatives who are trained in and expert in not getting reelected by district, but within the economic activities that they are representing on behalf of their corporation to which they belong. And he doesn't advertise the fact, but in fact what Hegel has is a system of universal representation. The only sore point is casual day laborers. How sore a point that is, I think, has been overestimated by Hegel's critics, partly because once you see the kinds of civil services that Hegel's arguing for, the administration of justice and public authorities, it's really easy to come up with the relevant solution for those who are, and for whatever reasons, remain casual laborers. Name an employment office who can help coordinate non-contract partial laboring. I mean, that's what the day laborers were, right? It was non-contract, no regular employment. And Marxists have said, this is, the beginnings of, the proletariat. And that's actually not true. Now, the town of Hanmünden has a very unusual geographical situation, location, right? It's the intersection of 3 major rivers, which also are not all at the same altitude. And so it was a major transportation hub, and an awful lot of loading and unloading of cargo went on in Hanmünden. And so there were lots of jobs available, even without long-term labor contracts in Hanmünden. And by the way, if you ever get a chance to go. It's a beautiful city. The old part of the city, it's really gorgeous. But this is the part that I noticed. In one of the main streets, there's this 4-story Fachwerkhaus, and someone has had a grill for the front door made of iron, and it is, in effect, a history tree of the owners of that building. One of them was a day laborer, right? Lohnarbeiter in Hanmunden, was well enough off to buy that house. You know, that's not exactly working scum at the bottom of the proletariat. And so we've got to be careful. Now, it may be that it's the only one there's ever been, but we've got to be really careful about our interpretation of these categories of employee or casual labor or whatever else. I mean, the actual economic history, of course, is more interesting than the rhetorical battles about it. My attempts, unfortunately, to photograph that front door failed. And so far, I have not been able to relocate it using Google Street View. But at some point, I'll manage to get back there and get the pictures I want. Is this an answer to your question? Okay.
My comment will be short and kind of formal. But first of all, I would like to express that I'm honored to meet you in person, because in my opinion, this book is one of the most precise interpretation of Kant's and Hume practical philosophy I've ever read, honestly. The fact that my main research interest is Kant's normative theory even more underlies my mentioned opinion. Because I'm doing my research on Kant ethical and his possibly meta-ethical theory, parts of the book that cover these areas particularly caught my attention. I have to highlight that I completely agree with your constructivist thesis to set aside moral realism and anti-realism, but not objectivity. Because that's the position I would also like to defend in my PhD thesis, defending Korsgaard interpretation primarily. So thank you again for this great contribution that also serves as inspiration. This book will definitely take high priority in my work. However, okay, but however, I have one dilemma. In the chapter Kant's Principles of Moral Constructivism, 22.1 section, a contradiction in conception. Yes. You present the two steps argument that saves universalization thus from paradise. This argument is, in my opinion, at least extraordinary, and it solves some of my personal dilemmas, so thank you for that too. But I have one more dilemma. I don't think that we need the first column of that argument. To be precise, I don't think that we can, or at least I cannot, find an example for ought with exclamation mark. A maxim that is consistent with corresponding universalization and its opposite maxim that is inconsistent with its corresponding universalization. I know that Kant in his work splits our acts in permissible, prohibited and obligatory, but I think that if he has an obligatory act, he cannot stave strict formalism, and your table, and I'm very glad of it, expresses Kant in strict formalistic sense. According to formalism, if I'm right, moral criteria represents a border between permissible and prohibited acts, or if you like, permissible and impermissible acts. So there is no room without implementing a content for obligatory acts. You can say that it is our obligation, for example, to return back money when we promise to return back the borrowed, but I don't think that is the real example of an obligatory act. This is rather the case of prohibited, impermissible act, because what is wrong in that act is a lie, a promise violation, and lie is something that we ought not to do, consequently the second column. I'm not inclined to call an obligatory act our obligation to restrict us from some acts. Furthermore, I think that request for real obligatory acts entails a danger of paternalism, because we cannot say that someone did something wrong from obligation and not from interest, for example, without looking at his or her intentions. To emphasize my point, let me give you one example. Kant's famous example for real obligatory act for first column, ought, is to help others whenever we can. I think that such an example passes the first step in your two steps argument, but also the second one, because there is no contradiction in conception when we consider a world in which nobody helps nobody. So that will be just a may act, not an ought act, the third column. To underline the point, I think that your solution for universalization test is even more greater, because I think that it implicitly shows that we cannot, or at least I cannot, find an example for the first column. And in that matter, we saved Kant's strict formalism and consequently his minimalism. The only thing that I disagree with is existence of the first column. We have to sufficient reason for infiltrating the first column. But as I mentioned many times, methodology for the universalization test and the other two columns are at least extraordinary. Thank you.
I think you can realize why it took me so long to figure out even this much. About intentions and moral worth in that first column, I deliberately just omitted issues about intentions, motives, well, not altogether intentions, but motives and moral worth. All right. I'm ready to let motives fall where they may. And for the purposes of this book, what I was trying to do was identify as directly as I could issues about whether or how and on what basis we can credibly distinguish obligatory from prohibited from permissible actions. And it's not that I think motivation is unimportant, and it's not that I think issues about moral character, moral worth are unimportant, of course. But I think that the relations are not to be had by conceptual analysis, the way people that have been debating internal and external relations between motives and reasons have been trying to do. It really is a matter for moral education, which is to say really the moral dimensions of all of our education. And to properly frame and pursue and assess those aspects of education, we need to have some fairly clear-cut distinctions and principles for distinguishing between obligatory, prohibited, and permissible forms of action. And then the further issue comes in about how these procedures and the pure a priori principles that Kant thinks help to constitute these procedures need to be used in connection with who we are as finite rational agents, right? The practical anthropology. And it's in that connection that I think that's one part of the connection that brings out the necessity for all three columns, or actually all four columns in the chart. As you know, Kant's own discussion of the distinction between what's consistent in conception and what's consistent in willing is one that he brings to bear on this issue about our obligation to lend aid to others in distress. And his own account of it in the groundwork already, but he, I think, doesn't revise it later. I think he stays with this account, is that precisely because we are such finite beings, simple precaution requires us to be careful about and, in the event, be prepared to deal with our own falling into distress in one way or another. And at that point, by the principle of hypothetical imperatives, as rational beings, we are committed to willing whatever resources are sufficient to relieve us of that distress.
And given our finitude and our social existence, among those resources are the possible voluntary assistance of other people. And what the universalization test rules out is anyone willing that others assist me while refusing to assist them, right? That's exactly the kind of exception to the universal requirement that Kant's test is designed to rule out. But you're right, it doesn't occur, none of the broad duties can be specified only at the level of formalism. I think none of the strict ones can either, right? I mean, even property rights only matter to us because part of our finitude lies in the fact that we can do nothing ex nihilo, right? For us to do anything, we have to make use of material resources, space, time, foods, I mean, a whole lot of different things, right? So right there, we're stuck with the task of sorting out how we can effectively and legitimately coordinate our actions so that we each can make sufficiently reliable, appropriate use of sufficient resources to maintain our own freedom of action. And, you know, the obligation to truthfulness also depends on, in part, on our practical anthropology. Kant makes this very plain in the last section of the anthropology lectures. You probably know this passage, right? He asks us, look, imagine that there's a species on some other planet more or less like us except for one thing. This is a race of rational beings that can only think by speaking aloud. Well, there's a race that can't engage in deceit because they can only execute a planned deceit by announcing their plans while they're carrying it out, including announcing it to their intended victims. Right? I mean, it's almost as bad as trying to lie to the omniscients. You know, you can prove you're a complete jerk and don't understand anything, but you cannot act effectively on your deranged attempt, either to deceive somebody to whom you're blathering all of your deceitful plans, or by trying to lie to the omniscience who already knows what you're trying to do, and by the way, knows the truth of the matter. So I think that the practical anthropology really has to be taken into account, and especially so also for the broad duties. And so it's not a mere formalism on Kant's view. I'm trying to think now of a case, of an example, and I think that, you know, the example of truthfulness will actually do here. I want an example that doesn't depend upon legal institutions.
Example for truth is in the second column, because that's our obligatory not to lie.
Well, no, there's also an obligation. I mean, you can do that by just being quiet. I think there's a separate.
But Kant also mentioned that we don't have a duty to always.
We don't have to. If we speak, we're obligated to speak the truth, but that doesn't always necessarily require us always to speak the whole truth. And we know that Kant acted on that policy. The other thing, and thanks for reminding me, about the two columns is that if we wanted to make use of some features of Kant's account of judgments and negation, we could indeed eliminate one of the columns, but then we would have to run the tests twice over, depending on where we put the negation in the relevant maxim. And yes, that can be done, but given the specifics and the intricacies of Kant's test, I much prefer risking a bit of redundancy to losing how precise is Kant's test to the often quite silly misreadings that too many Anglophones have provided us. Okay, so I hope you'll forgive me, but you're certainly right. We could deal with it, but then all we've done is complicated the use of the one remaining column and having to pay attention to Kant's. Right.
I know the purpose of
Right.
the table, and
Right.
I told you that I'm very thrilled.
Yeah.
It solves my dilemmas, but I just had little problem.
Yeah, good.
Okay.
Okay.
So we have time for one question, and I can't let you go not to ask you something. What do we discuss?
The price I pay. No. Thank you.
So what I missed in your book is some kind of more close investigation of the connections between justice and institutions. Why I'm asking that? We all know and we all remember how Rawls looked at the problem of justice and institutions. He said that the principles of justice for the institutions and principles of justice that apply to the individuals, they are not the same. For Rawls, that I think, and I see that for you all fundamental morality principles that apply to the institutions also apply to the conduct of the individuals. And that's what I'm also doing with my argument of constitutive justice. So for me, I would like to know how are you looking at the problem of origin or coming into being of institutions, die Entstehung der Institutionen. So what is the nature of institutions, social institutions? For me, as I go back and
Yes.
I found it some principles of justice that should be constitutive for every institutions, and that is of course connected to the notions of natural law that you are defending, because if you are traditional distinction. Natural law is moral political theory, and natural law is legal social theory. They are connected at the basic level. For your, as I understood you, and I think that's correctly. But that means then the natural law is a theological process. So that the law as itself, it's a theological process because we are putting something objective at the end, such as just society. Why? I mean, this is natural law constructivism, whether in Hume's or in Kant's version, focuses upon necessary conditions of social life, through which alone individual life and actions are possible. So then, I mean, you're Hegelian. You have to think natural law through the institutions, realized through the institutions. Yeah.
Yes.
I mean, that's a problem also for Kant, because for him.
It's not a problem. It's an issue. It's
Yeah.
something we have
Okay.
to deal with.
Okay. Yeah. So that connections between justice and institutions I missed in your book.
Well, you're right, because I was only trying to get so far. I have more to say about it in the next installment, which is on Hegel.
Yeah.
And I appreciate your reminder because I should go back and look at that part of Rawls. I'm sorry.
Thank you. I should go back and look at that part of Rawls and see what I want to say about that. You're right to suspect that I'm suspicious of his distinguishing them too sharply or categorically, because whose institutions are these, right?
And if the republicanism goes through, the small r republicanism, please, goes through, right, we are responsible for our institutions. And nobody else can be. Now, here again, and this too is completely Hegelian, I want to be careful about which aspects of the development or initiation of institutions matter normatively. I mean, typically institutions get started because at least someone is able, and some group is able, by developing this institution to at least achieve some of their free aims. And then the issue is whether their so doing is justifiable, acceptable, legitimate, or may even be something that we ought to be careful about and protect because it's in fact contributed to everybody's freedom of action. And so I'm absolutely with Hegel against the historical school of law, but also against and for confusion about historical development or origins with issues of normative assessment and justification. And so, I mean, certainly we can identify various social institutions that were instituted by corrupt, impermissible means. But this is part of where Hegel wants to point out that many of our customs and laws and institutions develop sort of much more locally and without premeditation, and yet may, in fact, achieve legitimate purposes. And this is why the issues about assessment matter so much, I think, in justice and in justification. And certainly Hegel's account of the institutions that he identifies within civil society and the administration of justice and the public authorities, all of those institutions are, on Hegel's view, required by principles of justice and can be and must be assessed in accord with principles of justice. And that will include the entire legal structure of a society. And that will include the laws that allow for the formation and operations of those institutions called corporations and foundations and so forth. And so, you know, we can get very quickly into some real nuts and bolts issues about what kinds of institutions we're talking about. And my guess is that Hegel's will get us into those nuts and bolts a lot quicker and with much better criteria for assessment than Rawls. I think that's what I can say now, but well, I'll come back to it tomorrow, I assure you.
Okay, thanks again very much.
Well, thank you all very much for your interest, your kind remarks, questions. Thank you. Thank you very much.